Coca-Cola is the largest beverage company in the world, with consumers of Coca-Cola soft drinks consuming 2.2 billion servings per day, which is one of the reasons Coca-Cola has a reported market cap of $266 billion. The second reason for Coca-Cola's success is that it has the world's largest beverage distribution system, where they have over 200 bottling partners worldwide, and specifically in Africa, which hosts Coca-Cola Beverage Africa, which is the 8th largest Coca-Cola bottling partner, making it the biggest on the continent. And this partnership led to the largest ever private equity investment in East Africa, as in 2019, Coca-Cola Beverage Africa acquired 100% of Nairobi Bottlers Limited and later on changed its name to Coca-Cola Beverage Kenya Limited. Currently, Coca-Cola Beverage Africa has 4 subsidiaries in Kenya, that is the former Nairobi Bottlers Limited. The second subsidiary is Almasi Beverage Limited, that Coca-Cola Beverage Africa acquired a 53.9% stake in 2019 in a billion shilling acquisition deal from Centum, which is a real estate company. The other 2 bottling companies are Crown Beverages Limited and Equator Bottles Limited. These Coca-Cola bottling companies manufacture, package, merchandise, distribute these soft drinks to suppliers who thereafter sell to consumers. In Kenya, Coca-Cola serves more than 40 brands, ranging from Coke, Fanta, Crest, to water companies such as Dasani, and in owning your richness, Keringet Water, effectively gaining Coca-Cola 70% market share of soft drink brands in Kenya. And this market success led to Coca-Cola facing a petition in court which alleged that Coca-Cola was discriminating against its consumers, as it was denying some of its loyal consumers information behind their crowd pleaser taste the feelings soft drink. Now, most food packages and soft drinks have product labels packed with consumer information stating the ingredients, nutritional claims, potential allergens, and other food warnings. Coca-Cola is no exception, and Coca-Cola is bound by its global responsible marketing policy, in which they market safe, quality beverages responsibly by providing information that consumers can trust. Coca-Cola displays such info on its bottle labels, and such info includes 1. The brand name, 2. The ingredients section, which includes ingredients such as carbonated water, caffeine, and artificial sweeteners. Thirdly, the label also includes nutritional info, which includes the size of the bottle, which can be either 1 liter or 500 milliliters. It also provides for the kilocalories, the nutrients per gram, the correct declaration of net contents in weight, volume, and number, which is important for those with dietary restrictions. 4th is the name and address of the manufacturer or distributor. 5th is the sell-by and expiration date. 6th is the storage directions. 7th is the customer care service contacts, which include email or phone number. And lastly, such labels can be used by Coca-Cola soft drinks to market their environmental friendliness. This is following Coca-Cola's innovation of plant-based bottles, which they claim is the first fully recyclable PET bottle, which is made from partially plant-based materials. Despite such display of consumer information on Coca-Cola bottles, they face a consumer violation petition in court. In the petition, Coca-Cola was being accused of discrimination. This is because whilst they voluntarily displayed consumer info on its plastic soft drinks labels, that is Coke and even Dasani bottles, they failed to display such information on its soft drinks glass bottles, which are much cheaper than the plastic bottles. The petitioner decried that consumers of glass bottles were being discriminated against because their glass bottles labels didn't include nutritional information, storage directions, nor did they have a customer care contact which consumers could register their complaints with the company. The petition further claimed that the discrimination was in the form of differential treatment to a class of consumers who could mostly only afford to drink from the much cheaper glass bottles. The petition claimed that such differential treatment was unfair because the impact of such discrimination is that a class of consumers were being deprived of the full benefit of information on the soft drinks they were consuming without reasonable justification. Such information was integral in providing consumers with nutritional info and info of the reasonable quality of the soft drinks, which would enable consumers to make informed decisions and compare which soft drinks brand is best for them based on their dietary needs. The consumer info on the labels also protect consumers from being misled by consuming soft drinks that are counterfeit soft drinks masquerading as a Coca-Cola brand. Further, the petition claimed that the discrimination is indirect as Coca-Cola was relying on a practice or procedure that appears to treat everyone equally but in reality treated those from lower economic background less favorably. Coca-Cola the minimalist. However, Coca-Cola's lawyers rubbished these claims and discredited the petitioner by claiming he wasn't a regular consumer of the soft drinks, therefore he couldn't file a petition for consumer violation against the brand. Coca-Cola based this line of defense on the fact that the petitioner admitted that he stopped consuming Coke following doctors' instructions and dietary restrictions. Shockingly, Coca-Cola's lawyers also argued that Coca-Cola legally did not have to provide nutritional info, storage info, or customer care info on the glass bottles because there was no law requiring them to display such info. They also claim that whilst the Kenyan Constitution Article 46, consumers are entitled to information necessary for them to get the full benefit of the soft drinks, Coca-Cola claims that they had complied by disclosing all information required, so much so that they had even met the standards required by the Kenya Bureau of Standards and acquired a certification. Further, they also stated that they had complied with the Foods, Drugs and Chemical Substances Act. In addition, they argued that the disclosures they made were in compliance with the Consumer Protection Act. Moreover, they argued that they had disclosed info regarding the name and address of the manufacturer on the glass bottle caps. And with this less is more minimalist effort, they argue that they had no further obligation to display nutritional info or storage info. Now, pertaining to the discrimination allegations between the plastic and glass bottles, they refuted these claims by arguing that consumers were spoiled for choice. They had a choice between which bottle to purchase from, which is self-defeating. Because are you stating that the consumers had a choice to choose between a plastic bottle that has information and a glass bottle that lacks consumer information? And that the consumers were clamoring in stores to knowingly, deliberately prefer purchasing glass bottles that lacked adequate consumer information. And this argument also doesn't account for the fact that consumers choose either of the bottles depending on price. The lawyers further doubled down and stated even if there was differential treatment, it was just mere discrimination and not unfair discrimination. They argue that whilst our constitution guarantees equal treatment, not all forms of discrimination are unlawful, and that our constitution only prohibits unfair discrimination, which according to Coca-Cola's lawyers, Coca-Cola wasn't discriminating against its consumers. They also argued that the price disparity between the plastic and glass bottles were because of commercial factors, and the fact that the glass bottles are recyclable, reusable, hence they are much cheaper. There was no discrimination in the price. However, Coca-Cola prides itself on sustainable packaging, so much so that it uses PET plastic bottles, which means that they are recyclable. Moreover, in 2021, Coca-Cola advertised their soft drinks bottles as plant-based, made from partially plant-based renewable materials, hence again recyclable. However, these eco-claims culminated in Coca-Cola being accused of greenwashing. Subsequently, in 2022, Coca-Cola made commitments to have at least 25% of all its soft drink brands being sold in refillable or returnable glass/plastic bottles by 2030. However, this commitment was recently shattered by Coca-Cola, one because of its leading rank as a single-use plastic top polluter, and also because Coca-Cola reneged on its 2022 promise to achieve 25% refillable/returnable glass/plastic bottles packaging target by 2030 after delegates from 200 nations failed to reach an agreement to reduce plastic products at the Global Plastic Summit held in Busan, South Korea. Following this summit, Coca-Cola has issued new targets to use 35 to 40% recycled materials in its glass/plastic bottles and increase their recycled plastic use from 30 to 35% globally by 2035. Now back to the case. The High Court rendered its judgment in favor of the petitioner, claiming that Coca-Cola had unfairly discriminated against its class of consumers who bought and drank soda from the glass bottles when they failed to provide nutritional info, storage directions, and customer care information. Disgruntled by this judgment, Nairobi bottlers would appeal to the Court of Appeal, claiming that the High Court judge had taken up the role of Parliament by directing Coca-Cola to include storage information, customer care information, and nutritional info on the glass bottle labels. This is because there was no law obligating them to do so. Moreover, they argued that the differential treatment of consumers was not unfair discrimination. They also argued that the petitioner was not a consumer of the Coke brand. However, the Court of Appeal upheld the High Court's decision and asserted that while Parliament makes the laws, the courts under the Constitution have a duty to develop the law and interpret the law in a manner that most favors the enforcement of a right or fundamental freedom. And with these grounds, the Court of Appeal held that the High Court judge could direct Coca-Cola to provide nutritional info, storage directions, and customer care contacts on the glass bottles. As for whether the discrimination was unfair, the Court of Appeal drew a distinction between direct versus indirect discrimination, with direct discrimination being the unreasonable treatment of someone or a group of people less favorably than others because of a specific attribute which they possess, which includes the race, sex, gender, tribe, religion, or disability, which are prohibited grounds of discrimination, whilst indirect discrimination is where there is a policy, rule, practice, condition, or requirement that applies to everyone but unfairly disadvantages a certain group of people without legitimate, rational, or reasonable justification for the differential treatment. And with this, the Court of Appeal held that the class of consumers who drank from the glass bottles were being indirectly discriminated against. Lastly, the court held that whilst consumers can report complaints to the Consumer Protection Advisory Committee, which has a duty to receive complaints and investigate them, the body doesn't have powers to determine constitutional violations. Only the High Court has that jurisdiction. Of course, Nairobi bottlers also dissatisfied with this judgment and they appealed to the Supreme Court, which also struck out the appeal. Currently, Coca-Cola is in the process of displaying adequate consumer information on its glass bottles. Interestingly, earlier this year, Coca-Cola stripped labels from its Sprite and Sprite Zero bottles in a limited trial of label-less packaging as part of its sustainability eco-friendly mission, which they claim will simplify their recycling process. So is the future of soft drinks packaging label-less?